Ms. Semel.
Thank you. Good afternoon. My name is Gabrielle Semel, and I am District Counsel for District 1 of the Communication Workers of America. I have represented CWA for close to 28 years, and prior to that, I worked as a field attorney in Region 2 of the NLRB for 2 years. During the last 30 years, I can safely say that I have participated in some manner in over 100 representation cases. Based on that experience, I believe that the board's R-case procedures are outdated and easily manipulated. Section 9C of the Act states that the board must determine whether a question of representation exists. The language of the statute should guide the types of issues that are litigated in pre-election hearings. In my experience as both a hearing officer and as a union attorney, that is generally not the case. Rather, the pre-election hearing is used as the strategic chip by the employer to either drag out the process or to gain an advantage in terms of the composition of the bargaining unit. The pre-election hearing is rarely about genuine questions of representation. A few years ago, I led CWA's legal work regarding 3 representation petitions seeking to represent geographically defined technical units of T-Mobile USA. These cases collectively illustrate some of the ways in which the board's current pre-election hearing procedures are abused. In the first petition, CWA-TU, a part of CWA, sought to represent all field and switch technicians in the state of Connecticut. The second sought to represent the same titles on Long Island in New York. And the third, the same titles in upstate New York. CWA-TU is a joint project with Verdi, a German union representing telecommunication workers in Germany. T-Mobile USA sought and got a hearing in each case. The issues were repetitive, did not raise genuine questions of representation, wasted the resources of the agency, the union, the employer, dragged the process out for many months, frustrated the wishes of the employees involved, and were completely unnecessary. In Connecticut, the employer sought to include radio frequency engineers, all of whom had college degrees in engineering. They challenged the labor organization status of CWA-TU and challenged the authorization cards as not running to the party that filed the petition because they referred to TU affiliated with CWA and not CWA-TU. None of these issues required a hearing as the facts were not in dispute. Nonetheless, a 4-day hearing was held. The regional director found, no surprise, that the RF engineers were professionals and not appropriately in the unit. He further held that CWA-TU was a labor organization and under the Act administratively determined that the authorization cards supported the petition. The employer raised the exact same issues in Buffalo, and a hearing on all 3 issues was then held in Buffalo again. The regional director in Buffalo ruled in the same manner as the regional director in Connecticut. If there was any justification for a hearing in Connecticut, there certainly was none in Buffalo. But in both cases, the hearings meant that the workers involved did not get to vote until months after the petition was filed. On Long Island, the employer claimed that the smallest appropriate unit was all of Long Island and the 4 boroughs of New York City. This is a fairly large, very densely populated geographic area. The employer produced virtually no documentary evidence of regular interchange between New York and Long Island technicians, and no evidence that the Long Island technicians were supervised by anyone other than their supervisors on Long Island. The hearing, however, took 7 days. The regional director found that the unit of technicians on Long Island was an appropriate unit. However, the decision was not issued until nearly 7 months after the petition was filed. This simply should not be. Even regarding the Long Island scope issue, the disputes were not really factual. Had the proposed rules been in effect a few years ago, all 3 cases would have been handled very differently. The regional directors would have been able to decide almost all the issues, if not all the issues, based on offers of proof, saving the resources of the agency and the parties while complying with the requirements of the Act. And the employees would have been able to vote in a timely manner. I would like to make one last point about disputes regarding unit composition and why I believe these issues should be left to post-election resolution in most cases, as the new rules propose. Often employers seek to include job classifications such as RF engineers or low-level supervisors to gain a strategic advantage. The employer does not really want them in the unit for collective bargaining purposes, but seeks to add potential no votes or, in the T-Mobile case, to drag out the process. The issues are not genuine questions concerning representation, but questions of strategy. After the election, if the workers elect union representation, the parties are generally able to resolve these disputes, usually without litigation, not on the basis of strategy, but on the basis of what makes sense for collective bargaining purposes. Thank you.
Thank you. Questions?
I'd like to invite you to sort of elaborate on this resolution of the disputes post-election and the impact on bargaining.
Well, I mean, the several cases that I have done where those things have been issues, had the parties been able to, if they could not reach agreement, and I think sometimes they could if offers of proof had been made, but if they could not, then after the vote is concluded, and if the union wins, then they can actually discuss what these people do and whether or not it makes sense for them to be in the same unit. I think, in my experience, a lot of those issues have been resolved. Through the years, I tried to think back of all the cases that I've been involved in to think of specific cases, but usually they've been resolved. Sometimes, if they're not resolved, there are procedures for handling that. But in my experience, most of the time, once the parties are no longer in adversarial position, they can figure out whether or not these people are really appropriate in the unit. If what they're really talking about is reaching a collective bargaining relationship.
In your experience, have you made decisions relative to taking on a supervisory issue in our case proceeding, and what impact, if any, had that been on the pursuit of the election?
We make these decisions all the time. In CWA in District 1, if we think that there's actually going to be an issue of supervisory status, we do not include those people in the petition. And the reason we do not include them in the petition is because we don't want to be in the position of having them be involved in an organizing campaign and tainting the process. And that's a real issue for unions as well. And we don't want to rely on them in any way, and so we do not, we err on the side of caution. But on the reverse, we have included people that we believe are low-level supervisors because we don't want to go through the process of a hearing. So without naming cases, because I realize the case I was about to mention is an ongoing case, although not an ongoing representation case, we agreed to a unit that included people that we thought were low-level supervisors because the board's procedures for hearings is so onerous that the time you can get to an election often means that workers are frustrated or and give up. I'm going to talk tomorrow about exactly what happened in all of these three units, and so I'm not going to talk about it here, but that is what happens. Workers get frustrated. They also get scared. They give up.
Thank you.
Couple quick questions. First, thanks for being here.
Thanks
Second,
for having me.
it's wonderful. I wish we had more time for everybody, but it is what it is. The genuine issue of disputed material fact standard in civil litigation under the FRCP is the subject of many, many decisions, some even going up to the Supreme Court because it's not the easiest standard to apply. From your perspective as a practitioner and leading labor lawyer at one of the leading unions in America, how are we going to impart to people in the regional offices, here's what this standard means in the given nature of our cases to avoid having it crop up again and again and again, because this is something that district court judges blow all the time.
Well, first I just want to say one thing about people in the regions. I don't think any of these problems have been caused by the people in the regions. I mean, I think the people in the regions work incredibly hard, and I have tremendous respect for the work they do. I don't think that is the problem. The problem really is the process, and the fact that the process is easily open to manipulation. It was when I was a board agent and a hearing officer, and it still is. So I personally think that there should be training. And there should be training for people who are going to be hearing officers on how to look at these questions. And I believe that when these issues are complicated or not easy to decide, the regional directors should make that decision. And that's exactly what happens now. If you're in a conference regarding a representation issue or even a hearing, and the hearing officer realizes that there is a complicated question, he or she will stop the proceeding and go and speak to the front office and get guidance. So in my experience at the board, there is no problem with getting the regional director's decision on an issue that is not clear. But on some of the issues, for example, are there material, in the examples that I gave, were there any material facts at issue? The RF engineers, there was no material facts at issue. We would have all agreed. They could have presented the job descriptions. We would have agreed to them. They would have explained what the educational background of all the people were. We would have agreed with them. That's a legal question. We didn't need a 4-day hearing on that question.
Right. Some issues may be a little closer
right.
than that, is all I'm suggesting.
Without a doubt.
Then the follow-up to that is basically, okay, so let's say you have a hearing officer that rules, look, there's no genuine issues here. Boom. Whole case goes away. Gone. No opportunity for review. In effect, some might argue, some commenters might argue that the hearing officer has now made a recommendation that has controlled the entire case. How do you respond to that?
Well, I mean, I think that on most of these questions, I guess what you're asking seems to me very far-fetched, to be really honest. It's not my experience that many questions are that complicated. In other words, experienced labor practitioners really do understand the standards for inclusion and exclusion of various job classifications. People know that. And I don't really think I don't think it's that big a problem, and I don't think that the rules should be decided on the exception. The rules should be decided based on what the needs of what the act is for, and representation of working people. They deserve to get a vote and not be hung up in, sort of procedural questions all the time, not knowing what's going on. But to your point, I think for the exceptions, I think that there can be guidance to hearing officers that in these kinds of cases, you must consult with the regional director so that the hearing officer is not the decision maker.
Okay.